So we are going to start dimension number 4 in unit number 1. Dimension number 4 is all about constitutional amendment and the doctrine of basic structure of Indian Constitution. So under this topic we will be studying about first constitutional amendment, and second the doctrine of basic structure. The doctrine of basic structure of Indian Constitution. So let's put down the heading constitutional amendment. See, Constitution is represented through its provisions, right? Through its provisions. For example, let's say Article 17. Article 17 is undoubtedly one of the provisions of Indian Constitution, and Article 17 tells us about abolition of untouchability. So, in one way, you can say that Article 17 makes the provision for abolition of untouchability. At the same time, on the other way, you can also call it like Indian Constitution makes the provision for abolition of untouchability. Look, Article 17 states about abolition of untouchability. Don't you think this particular statement can be expressed in other way, calling Indian Constitution makes the provision for what? Abolition of untouchability. So what does it mean? It simply means that Constitution is represented via means of its provisions, right? Okay. Constitution means its provisions.
मेरे सिस्टम में साउंड नहीं आ रहा है सर, थोड़ा वॉल्यूम आप वहां से बढ़ा सकते हैं सर प्लीज? नहीं सर, क्लियर।
आई थिंक आपके एंड से कोई प्रॉब्लम होगी थोड़ा। आप अपने सिस्टम को एक बार रिफ्रेश करिए। हाँ ठीक है, देखो, in general constitution is meant by its provisions. So whenever you talk about constitutional amendment, don't you think it is largely meant by amendment across the provisions of the constitution? Good. So constitutional amendment means amendment across its provisions, and we are talking about amendment to Indian Constitution. So amendment to Indian Constitution means amendment across the provisions of Indian Constitution. Good. So just try to understand this analogy, right? Amendment to Indian Constitution means amendment across the provisions of Indian Constitution, right? Indian Constitution. And you must be knowing the fact that Indian Constitution has both flexible and rigid provisions. Good. Let's copy them down. Amendment means changes. Changes. The provisions of Indian Constitution are of two types. One is flexible provisions and the other is rigid provisions. In earlier classes, while studying about the features of Indian Constitution, we have discussed one feature, and that feature was our Constitution is the unique blend of flexibility and rigidity, unique amalgamation of flexibility and rigidity. In due course of carrying out discussion upon that facet, we discussed that flexible provisions are those provisions which can be amended easily, while rigid provisions are those provisions which are amended but they cannot be amended easily. Yes. So flexible provisions are easy to amend, while rigid provisions are difficult to amend, right? Difficult to amend. See, flexible provisions are amended by the Parliament of India through law. In other words, you can say the Parliament of India by law can amend the flexible provisions. Here, law is basically the result of ordinary legislative jurisdiction of the Parliament. The Parliament by law can amend the flexible provisions. And at the same time, here law means ordinary law. Remember, law means ordinary law. Law means ordinary law. When it comes to carry out amendment across rigid provisions, remember again, the Parliament will be amending them, but not through law. Parliament by law cannot amend the rigid provisions. It can amend only flexible provisions. Then the question is, how to amend the rigid provisions? So look, here the Parliament by constitutional law, right? Constitutional law can amend it. We have also understood in previous classes that constitutional law is known by the name of constitutional amendment under Article 368. See, we have already seen that the Parliament of India enjoys two sets of legislative powers. It has two sets of legislative powers. One is ordinary legislative power, and the other is constituent legislative power. Whatever the Parliament of India commits within the purview of its ordinary legislative power, it is called what? Law. Here law means ordinary law, ordinary law. And whatever the Parliament of India performs within the ambit of its constituent legislative power, the result is what? You can call it either constitutional law or an amendment under Article 368. This is called constitutional amendment. So remember, constitutional amendment is a formal terminology. So whenever it says yes, this is going to be a constitutional amendment, it means the Parliament is going to entertain, going to enjoy its constituent legislative jurisdiction. Okay. Simple amendment means amendment across ordinary provisions, amendment across flexible provisions, that is formally not referred to as constitutional amendment. For example, suppose the government of India has decided to change the name of Uttar Pradesh and renamed it like Uttam Pradesh. So if Uttar Pradesh is going to be changed as Uttam Pradesh, obviously some sort of changes needs to be carried out across Schedule 1 of Indian Constitution. But carrying out amendment across Schedule 1 of Indian Constitution is actually not the constitutional amendment, it's an ordinary amendment. And to cause this ordinary amendment, Parliament does not require to enjoy its constituent legislative power. Parliament can do so, Parliament can amend such provisions by law. By law. Is it okay? Yes. So, constitutional amendment is basically the subject matter of Article 368 of Indian Constitution. Article 368 is given under Part 20 of Indian Constitution. Okay. So, in Part 20, it comes what? Article 368. And Article 368 deals with the entire procedure which is required to cause constitutional amendment. At the same time, Article 368 also tells you about the power of the Parliament to amend the Constitution. Is it okay? So, Article 368 deals with two sets of information. It deals with two sets of information. First, the procedure which is needed to carry out constitutional amendment. Constitutional amendment. In other words, you can also call it Article 368 deals with the procedure which is needed to formulate the constitutional laws. The constitutional laws. Remember, in India, constitutional laws are the supreme laws. Supreme law. Ordinary laws need to show consistency with the constitutional law. In case an ordinary law stands inconsistent to a constitutional law, the ordinary law shall be declared as unconstitutional up to the extent of whatever the inconsistency being carried out by ordinary law. So, up to the extent of such inconsistency. Okay. Second thing which is given under Article 368 is Article 368 also makes us know about the fact that it is the Parliament of India which has been provided with or vested with the power to amend the Constitution under Article 368. Okay. So, the power of the Parliament to amend the Constitution. The power of the Parliament to amend the Constitution. I mean, two sets of things have been enumerated under Article 368 in Part 20. First, what should be the procedure which is needed to be followed while amending a rigid provision. Secondly, it also affirms that Parliament of India has been provided with the power to amend the constitution. So two sets of informations are derived from Article 368 given under part 20 of the constitution. That's it. Okay. So if you look into the procedure which is required to be followed while carrying out constitutional amendment, that procedure is slightly difficult. That procedure is slightly difficult. So Parliament needs to apply a special majority while passing a constitutional law, or in other words, you can say while carrying out constitutional amendment. But when it comes to cause certain changes across the flexible provisions of our constitution, Parliament does not require to follow the procedures enshrined under Article 368. No. Parliament, by following ordinary legislative procedure, can amend the flexible provisions. Now the question is, which kind of majority is employed while amending the ordinary provisions, or you can say flexible provisions? So in order to amend flexible provisions, Parliament needs, simple majority. Simple majority. While amending the rigid provision, Parliament needs which kind of majority? A special majority. In common parlance, this special majority is called as two-third majority. Which kind of majority? Two-third majority. Special majority or two-third majority. So before moving further, let me make you understand about the concept of majority first. So after understanding the concept of majority, we will return to this ongoing discussion. So please put down a subheading, concept of majority. See, in India, when it comes to legislative business, certain kinds of majority are followed. For example, simple majority, then it comes absolute majority, then it comes effective majority, then it comes special majority. Special majority. Remember, this special majority is also of three types. So, in India, three different types of special majority are followed. One is special majority given under Article 249. So Article 249 tells you that what should be the nature of special majority given under it. Okay. And how this majority needs to be employed while discharging the legislative business. Second kind of special majority is special majority given under Article 61. Then it comes special majority given under Article 368, which is going to be the chief concern for us right now. 368. So let me repeat this. Special majority are of three types: special majority under Article 249, special majority under Article 61, special majority under Article 368. Okay. See, under constitutional amendment, right? Under constitutional amendment, we need to utilize two sets of majority for constitutional amendment under Article 368. The kind of majority which has been explained under Article 368 shall have to be used. While getting the flexible provisions of Indian Constitution amended, we need to apply simple majority. Simple majority. So, look. Simple majority, absolute majority, and effective majority. They all are called as 50%. I mean, more than 50% kind of majority, right? More than 50% kind of majority. Just try to remember this simple pattern. So, simple majority is more than 50% kind of majority. We shall be looking into more than 50% of what? So, we shall be looking into that what? Absolute majority means again more than 50% of something. Effective majority means more than 50% of something. But such somethings, they are varied in nature. We will be looking into that. Special majority. We have three sets of special majority. One is special majority under Article 249. Second is special majority under Article 61. Third is special majority under Article 368. So, what should be the common pattern that could be followed over here? Look. Here in special majority, you need to follow a simple pattern. That pattern is not less than two-third kind of majority. Remember, it's not like something more than two-third. No, not less than two-third. Not less than two-third. Even if two-third is there, the majority would be satisfied. If it is more than two-third, then well and good, no problem. But if it is less than two-third, then it is unwarranted. Okay. Now, let's try to find out that something, that what, like 50%, more than 50% of what, not less than two-third of what. So, we are going to find out what is what. What is what? Let us consider that Q3IAS has announced, the admission for a new batch, which is going to be started after 15th of August this year. And in that batch announcement, it has been announced that a total of 100 students would be enrolled only. 100 students. Although the capacity of the classroom is 120. The capacity of the classroom is 120. Yet the institute administration or management has decided to take admission for how many seats only? 100 seats. Okay. So, first figure is total capacity. So, total capacity is how many? 120. But total number of seats on which the admission has been invited, that is called total strength. Yes. So, 100 would be what? Total strength of that batch. Total strength is 100. All right. So, admissions have been done, no problem. But after going through 4 to 5 classes in Indian polity and constitution. Suppose 10 students have decided not to continue with the classes. The reason being they are unsatisfied of polity teacher or polity lectures. So a vacancy on how many seats have been created? 10 seats. 10 seats. So total number of vacancy is 10. See, total strength is 100, but a permanent vacancy has been created on how many seats? 10 seats. So don't you think effective strength would be 100 minus 10, that is 90 only? Yes. So now it comes the concept of effective strength. So effective strength is all about total strength, minus vacancy. Means if vacancy be reduced from the total strength, whatever the residue you find, that is basically effective strength. So 100 minus 10, that is 90. 90 is going to be the effective strength of the batch. Okay, fine. One more thing. Suppose on 14th of August, I could have made an announcement that regarding ongoing batch, we are going to take certain peculiar decision, but that decision would be taken based on the opinion of the students. The opinion will be garnered based on majority principle. Okay, and the date of that opinion making and decision making would be 21st of August. Certain students had, so suppose certain students have decided that uh, there is no benefit of attending such session. Why? Because there will be no discussion on any topic or any subject. The entire time will be invested merely on decision making. So we have nothing to give or take with that decision making. And suppose 5 students, remember they are the part of effective strength, they are the students of this batch, yet they have decided that the ongoing session is not going to be the fruitful one. That's why to attend such unnecessary session? Let's remain at home, take some rest. And they have decided not to attend the session. So 5 students, they have absented themselves. These students have absented themselves. Okay. Suppose 3 students are ignorant of the ongoing event. They simply came into class. They are thinking of certain topic will be discussed. Meanwhile, they got to know that no lesson will be taught. We are simply here to make a decision upon a particular issue, upon a particular topic, and the decision would be based on majority principle. So voting is going to be conducted, and instantly they came to know about this fact, and finally they decided why to waste time in class, and they just abstained from the class. They just abstained themselves from the class. So thereby 3 students have abstained themselves from the class. See, there is an absenteeism of 5 students, and you know how many students are abstainees? 3 students are abstainees. So 5 plus 3, that is 8. Look, out of 90 students, 10 students are not going to take part in voting, or in other words, they are not going to take part in decision making. They are not going to take part in voting. So, total number of students who are present in the class and going to take part in voting, what would be their figure? 80? 80. So, total number of students present and voting is how many? 80. 80. Now, yes, while finding out majority, look, this figure is employed, this figure is used, total strength. First thing, again, while finding out some other kind of majority, this figure is also used, the figure of effective strength. While finding out majority, this figure is also used, total number of students present and voting. So, total capacity, it is never used in finding out majority. You need to remember only three figures. Three figures means total strength, effective strength, and present and voting. So let's get it summarized. What's the figure across total strength? Good. 100. What's the figure across effective strength? 90. What's about present and voting? Good. Present and voting. 80, right? 80. Yes. So only these three figures are going to be utilized while finding out different kinds of majority. Okay. So let us consider that total strength is X, effective strength is Y, effective strength is Y, present and voting is Z. Z. Now, return over here. Simple majority, absolute majority, effective majority. The common thing associated to all these three kinds of majority is what? More than 50% kind of majority. So, while finding out simple majority, you need to apply Z, not XY. You need to apply Z. Means more than 50% of Z. Z means present and voting. Have a look. Present and voting. Z. So the figure is obvious to all of you. The value, numerical value of Z is what? 80. 80. So more than 50% of 80 would be what? 41. 41. So 41 is simple majority. 41 is simple majority. Okay. Now move on to absolute majority. Again, it's more than 50% kind of majority, but the question is more than 50% of what? So more than 50% of X. X stands for total strength. What's the numerical value of total strength? 100. So more than 50% of 100, that is 51. Don't you think this is slightly difficult majority? Yes. What's about effective majority? More than 50% of Y. And what's the figure of Y? 90. So what's the numerical value? 46. Hopefully you would have understood it. And don't you think the common point is more than 50%? More than 50%. In case of simple majority, more than 50% of the total number of students present and voting. Absolute majority means more than 50% of the total strength of the class. The total strength of the class. Effective majority means more than 50% of effective strength. And how to find out effective strength? by getting the vacancies deduced from the total strength. Whatever the figure you obtain, that is basically the figure of effective strength. So more than 50% of effective strength would be referred to as effective majority. So if they are clear, then I will switch over upon special majority. Online students, please get it confirmed. Have you got the point?
Yes, sir.
Good. Now, special majority. Special majority. How many types of special majority are there under Indian Constitution? 3. Good. What are they? Special majority under Article 249. Then it comes special majority under Article 61. And third one is
368.
exactly special majority under Article 368. Basically, our concern is 368, but in order to make a develop a clear-cut understanding, we have decided to go through all the different kinds of majority. See, special majority under Article 249, 61, 368. In case of all the three, we follow a common pattern. What is the name of that pattern? Not less than two-third kind of majority. Not less than two-third kind of majority. It means special majority under Article 249 should be not less than two-third. Now the question is not less than two-third of what? Not less than two-third of Z. What's about Z? Present and voting. Present and voting. So what's the numerical figure of present and voting? 80. 80. So not less than two-third of 80. Is it okay? So 26.6 bar on head of 6 multiplied by 2 results into what? 53. 53. So not less than 53. Not less than two-third of present and voting. Fine. Special majority under Article 61. Special majority under Article 61. What is this? Not less than two-thirds total strength. So what's the total strength? 100. 100. So what would be the two-third value of 100? 67, right? 67. 67. People are not counted in fraction. लोगों को काट के काउंट करेंगे क्या? नहीं. People are not counted in fraction. So 67. 67. Now, a special majority under Article 368. Remember, it's a unique kind of special majority. It is basically a mixed kind of majority. So, in order to find out a special majority under Article 368, first of all, it is needed to find out a special majority under Article 249. A special majority under Article 249, first thing, means there should be a figure like not less than two-thirds of present and voting. First thing. Second, whatever the total strength of the house is there or the class is there, you need to find out absolute majority. Absolute majority. So see, all such decisions regarding how to apply majority, how to find out majority, it is conducted under the leadership of, under the chairmanship of presiding officer. Presiding officer. So suppose such kind of activity is being carried out in Lok Sabha. So obviously it would be conducted under the leadership of the Speaker Lok Sabha. If it is happening in Rajya Sabha, it will be conducted under the chairmanship of Rajya Sabha chairperson. Okay. So it is known to one and all, it is known to everyone that what is the total strength of Rajya Sabha, what is the total strength of Lok Sabha. Just forget them. We have taken the example corresponding to our classes. So while putting down different figures, we have simply assumed that the total strength for the forthcoming batch in Q3IAS would be how many? 100. 100. Though the capacity is of 120, but the admission was announced for how many seats? 100. So 100 is the total strength. No matter how many vacancies are there, no matter in due course of conducting the voting, how many members have abstained themselves from taking part in voting, but total strength is evident to all. Total strength is obvious to all. Everybody knows about total strength. Why? Because on the same strength, the admission has been announced. So total strength is 100. Considering total strength, we find out absolute majority. Absolute majority. So absolute majority is obvious to everyone. So there is no need to find out it. If the total strength is 100, obviously absolute majority is 51. 51. So this figure you need to keep in your mind. Keeping this figure in your mind, now we are required to find out a special majority prescribed under Article 249. And how the special majority prescribed under Article 249 is conducted? It is found out like a majority of not less than 2/3 of present and voting. So how many students are present and taking part in voting? 80. 80. 80. So what should be the figure of, what should be the 2/3 value of 80? 53. 53. So now make a comparison between these two sets of figures. Figure of absolute majority is 51. Figure of special majority under Article 249 is 53. If this figure is either equal or greater than 51, then you say a special majority under Article 368 got satisfied. But if this figure is less than the figure of absolute majority, then a special majority under Article 368 won't be satisfied. Have you got the point or not? But for the sake of satisfaction, let me crack yet another example. Look, let us consider that only 66 members are present and voting out of the entire effective strength of 90. How many students are available in the class, and not only available in the class but also taking part in voting? They are 66 in number. Just find out 2/3 of 66. 44. 2/3 of 66 would be 44. 44. Don't you think this is the special majority under Article 249? But here you are finding out a special majority under Article 368. And under Article 368 expects you to follow certain distinct norms. In such distinct norms, first of all, you need to find out, you need to, consider the figure of absolute majority. Yes, please. Absolute majority. So what's the figure of absolute majority? 51. So the figure of absolute majority is 51. But 2/3 majority out of the number of members present and taking part in voting is how much? Don't you think this figure is less than the figure of absolute majority. So, special majority under Article 368 has not been satisfied. Hopefully, you would have understood this concept, how to find out a special majority under Article 368. So, the value of absolute majority is obvious to the presiding officer. So, presiding officer, keeping in his mind the value of absolute majority, he curates the house to go on for two-third majority out of present and voting. So, whenever the two-third majority out of present and voting is found out, now that figure will be compared with the figure of absolute majority. If that figure means the figure of two-third of not less than two-third of present and voting, if that is lower than the figure of absolute majority, then special majority under Article 368 won't be satisfied. If it is equal or greater than the figure of absolute majority, then special majority under Article 368 would be satisfied. Is it okay? Yes. But I know it well that after 2 to 3 days, there will be a possibility that you will forget this concept. So, please take down the steps how to find out special majority under Article 368. The steps followed to find out special majority under Article 368. 368. First step. Step 1. Find out the value of what? Absolute majority. Absolute majority. Remember, absolute majority is never used in house uniquely. Means it can never be used alone in the house. Whenever it is used in house, it is used along with Article 368. So, in case of Article 368 only, absolute majority is used in house. Yet, it is very much important for our democratic practices. Once a general election to Lok Sabha or state legislative assembly is conducted, the fate of the government is decided based on the figure of absolute majority. Absolute majority. Absolute majority means a majority of more than 50% of the total strength of the house. For example, when it comes to the general election to Lok Sabha, you know it well that general election is announced on how many seats? 543 seats for Lok Sabha in year 2024. So, what should be the absolute majority out of this figure? 272. So, a party or a coalition of parties, if that is successful in finding out this magical figure, it is assumed that we are going to have a stable government. So, in absence of absolute majority, the parliament comes into, or the parliament becomes a hung parliament. Hung parliament, or state assembly becomes a hung assembly. Hung assembly or hung parliament means unstable government. So, in order to provide stability to government, it is required to fetch the figure of absolute majority. So, this is the reason why absolute majority becomes important and relevant in electoral democracy or liberal democracy or parliamentary democracy. Okay. But in house, it is never used alone. Yes, effective majority is used. For example, when it comes to remove the Vice President of India from his office, a resolution needs to be passed in the upper house of Union Parliament, or you can say in the Council of States, that is Rajya Sabha. So in the Rajya Sabha, a resolution seeking the removal of the Vice President of India shall be tabled. And that resolution needs to be passed with the help of which kind of majority? Effective majority. Effective majority. So once such resolution be passed with the help of effective majority in the Rajya Sabha, then it will be moved on to Lok Sabha. Lok Sabha will have to, conduct a mere formality by getting that resolution ratified with the help of simple majority. Simple majority means a majority of more than 50% of the members present and voting. And this is how chairperson Rajya Sabha, or in other words, you can say Vice President of India, is removed from his office. One more thing. Speaker Lok Sabha, Deputy Speaker Lok Sabha, Speaker Legislative Assembly, I mean State Legislative Assembly, Deputy Speaker State Legislative Assembly. If bicameral state legislature is there, two house legislative system is there in a particular state like Bihar, UP, Maharashtra and all. If it is needed to remove the chairperson or deputy chairperson of the upper house of state legislature, that is Vidhan Parishad, I mean Legislative Council, again effective majority is employed. Effective majority. But while getting a speaker elected, I mean speaker to Lok Sabha, speaker to Legislative Assembly, again deputy speaker to Lok Sabha, deputy speaker to Legislative Assembly, they are elected with the help of simple majority, but removed with the help of effective majority. Obviously, all such majorities are employed in-house, because in due course of removing the Speaker Lok Sabha from his office, the Lok Sabha shall be passing a resolution seeking to that effect with the help of simple majority, I mean effective majority. While getting him elected, again the Lok Sabha will pass a resolution with the help of which kind of majority? Simple majority. So simple majority, effective majority, they are used in house, but absolute majority, it is never used in house alone. It is never used in house uniquely. But when it comes to the amendment to the constitution following the norms prescribed under Article 368 in Part 20, when a special majority is to be employed, first of all, it is needed to find out absolute majority. And that absolute majority is applied in house. So first of all, absolute majority is found out. After that, a special majority under Article 249 is found out. How to find it out? By applying a simple algorithm that a majority of not less than 2/3 of the members present and voting. So thereby you will obtain another figure like majority of not less than 2/3. Okay. Suppose a majority of not less than 2/3 figure is found out in form of y, and the figure of absolute majority already we are having is basically x. So you need to make an assessment between these two sets of figures. If y is either equal or greater than x, then a special majority under Article 368 would be satisfied. If it is not, then a special majority under Article 368 won't be satisfied. So actually the same pattern we are going to enumerate alphabetically. Like in step 1, find out the value of absolute majority. What should be step 2? Yes, find out, yes, the special majority under Article 249. Okay. And then the figure obtained through step 2 shall be either equal to or greater than the figure which was found out under step 1. So third step, if the value obtained in which step? Second step, right? In second step is either greater than or equal to the value obtained in exactly step 1, then the special majority under article 368 would be satisfied, otherwise not. So hopefully you would have understood the concept of majority. Yes. Shall I change the slide? So this majority means majority given under Article 368 is employed in constitutional amendment. This majority is employed in removing the judges of higher judiciary from his office while passing a resolution seeking to that effect from the parliament. But when the president of India would have to be impeached, you might have heard that a special majority is employed in order to pass such resolution seeking the removal of president from his office, or you can say impeaching the president from his office. So which kind of special majority is employed? No, special majority under Article 61, and this is the toughest kind of majority given under Indian Constitution. So how to find out special majority under Article 61? Not less than 2/3 of total strength of the House. Special majority under Article 61 means not less than 2/3 of total strength of the House. Imagine how difficult it is. And remember, not less than 2/3 of total strength of the House. This kind of majority is employed only and only in case of impeaching the President of India from his office. In other cases, this majority is not employed. So look, no, governor, bears his office only during the pleasure of the President of India. So governors are appointed and they hold their office up till President wants them to remain in their office, and wants or non-wants of President is not his or her own opinion. Rather, it is the opinion of the Council of Ministers headed by the Prime Minister. So willingness of President or non-willingness of President is basically the willingness or non-willingness of the Council of Ministers headed by the Prime Minister. So governor is appointed and holds his office only during the pleasure of the President of India. The President appoints the governor, and governor shall remain in his office as long as the President wants him to remain in the office. Here, wants of President is actually the wants of Government of India. Government of India is denoted as the Council of Ministers headed by the Prime Minister. Right? Yes. So look, to impeach the President of India, a special majority is employed. In other words, 2/3 majority is employed. But you need to know the technical difference that is lying amongst all the three different kinds of 2/3 majority. Even Article 249 talks about 2/3 majority. Article 249 talks about special majority. But can this special majority be equated with special majority that has been discussed under Article 368? No, they are different. Can special majority under Article 368 be equated with special majority that is given under Article 61? No, they are different. So now, hopefully, you would have understood the technical differences which are lying amongst all these three different kinds of special majority. Now, return to topic. Our conceptual discussion was going on across amendment to the Constitution of India. And we have understood that Constitution means its provisions. Constitutional amendment means provisions across, yes, I mean amendment across the provisions of the Constitution. Amendment to Indian Constitution means amendment across the provisions of Indian Constitution. And it is known to all of us that Indian Constitution has two sets of constitutional provisions, flexible and rigid. Flexible and rigid. Flexible provisions are easy to amend, rigid provisions are difficult to amend. How to recognize such easiness or difficulties? The easiness lies in the fact that in order to amend a flexible provision, it is not required to follow the path of special majority. Rather, it is amended by following the path of simple majority. And remember, to amending both the pieces of constitutional provisions, Parliament is the principal authority. So, Parliament has been empowered by Indian Constitution to cause constitutional amendment, no matter whether it has been talked about the flexible provisions or the rigid provisions. For example, in order to amend flexible provisions, Parliament will simply make an ordinary legislation, or you can say the Parliament will simply make a law, and via means of that law, flexible provision would be amended. Flexible provision would be amended. And in order to make ordinary law, which kind of majority is employed? Ordinary majority, simple majority, simple majority. So, simple majority is very simple. A majority of more than 50% of the total number of members present and voting. And look, the total strength of Lok Sabha is 543. Okay, so in order to you can say continue with the proceedings of the Lok Sabha, the minimum quorum of legislatures which is required is basically the 1/10 of total strength of the Lok Sabha. So total strength is 543. What would be the figure for Lok Sabha quorum? 1/10 of 543 is 54. I mean 55, right? 543, 54.3, that is 55. So if 55 members are present in the Lok Sabha, the proceedings of Lok Sabha will be conducted. And in such proceeding, if it is required to pass certain legislation with the help of simple majority, they can do so. They can do so. Yes, if the Lok Sabha finds itself unable to fulfill the quorum, suppose the total number of members present in the Lok Sabha is less than 55, in that case, the proceeding of Lok Sabha won't be conducted. So, in order to carry out the Lok Sabha proceeding, the minimum number of legislatures which is required is 55. In case of Rajya Sabha, look, total strength of Rajya Sabha is 245. So, what would be the figure to fulfill the quorum of Rajya Sabha? 25. 25. 10% of, 1/10 of 245. Anyway, so even if suppose 60 members are present and taking part in Lok Sabha, so more than 50% of this 60, that is 31. So even with the help of 31 members to Lok Sabha, flexible provision of Indian Constitution can be amended. So don't you think such provisions are very much easy to amend? That's why they are called as flexible provisions. But in case it is needed to carry out amendment against a rigid provision, now the Parliament shall have to follow the path of constituent legislative jurisdiction. The Parliament needs to follow the procedure prescribed under Article 368, and whatever the procedure prescribed under Article 368 is difficult one. Difficult one. For that, the parliament needs to follow two-third majority pattern. See, there are three patterns associated to two-third majority. One is given under Article 249, other is given under Article 61, and other is given under Article 368. Which one is required over here? 368. 368. Okay. See, under Indian Constitution, the concept of constitutional amendment has been derived from the constitutional scheme of which country? What would be your response? South Africa. South African Constitution. So, the concept of constitutional amendment under Indian Constitution had been derived from which constitutional scheme? South African Constitutional Scheme. Fine. Look, our constitution has how many sets of provisions? Two sets. What are they? Flexible and rigid. Flexible and rigid. So, the procedure which is to be followed to amend the flexible provision needs to be easier one. This concept has been derived from which constitutional scheme? British constitutional scheme. Which constitutional scheme? British constitutional scheme. Flexible provisions. Such provisions should be amended easily. Means there is no need to follow any kind of difficulty. Okay. This concept has been derived from British Constitution. Okay. While amending the rigid provisions, complex procedure needs to be followed. While amending the rigid provisions, complex procedure need to be followed. Such kind of concept has been derived from which constitutional scheme? US constitutional scheme. Difficulty in amendment. USA's constitution. So here you need to remember three sets of information. First one is Indian constitution can be amended. This concept has been derived from which constitutional scheme? South African constitutional scheme. Fine. Flexible provisions of Indian constitution should be amended by following easier legislative business, easy legislative procedure, simple legislative procedure. This concept has been derived from which constitutional scheme? British constitutional scheme. Rigid provisions should not be amended easily. Rather, there should be a complex procedure to amend the rigid provisions. Such concept has been derived from which constitutional scheme? US constitutional scheme. Is it okay? Fine. So look. So under Indian Constitution, if you look into the constitutional provisions, primarily you will have two sets of constitutional provisions. Two sets. One is flexible ones and the other is rigid ones. But here you need to be specific. Rigid ones. Remember, out of all the rigid provisions of Indian Constitution, there are certain rigid provisions which are having greater extent of rigidity. while there are some other rigid provisions which are having less degree of rigidity. Means all the rigid provisions are not having equal extent of rigidity. All the rigid provisions are not having equal degree of rigidity. Some are more rigid, some are less rigid. Some rigid provisions are less rigid and some rigid provisions are more rigid. More rigid. Remember, those rigid provisions which do not take part in division of power under Indian federal structure, they are less rigid in nature. While those rigid provisions which take part in division of power between center and states, they are more rigid in nature. Means those provisions which take part in division of power between the center and states, they are more rigid in nature. And those provisions which do not take part in division of power between the center and states, but they uphold the philosophy of Indian Constitution, they are less rigid. For example, preamble to the Constitution of India, fundamental rights, DPSPs and all. If such provisions are to be amended, you know, they are less rigid, because they do not take part in division of power between center and states. They have nothing to give or take with India's center-state relationship. But when you go on to cause amendment across Schedule 7 of Indian Constitution, which talks about the division of legislative powers between the center and states by means of three different lists, like union list, state list, concurrent list, in such situation, you need to treat them as more rigid provision. Which kind of provision? More rigid. So look, here less rigid provisions are those provisions which do not take part in division of power between the center and states, but they exactly uphold the philosophy of Indian Constitution. They are also the rigid provisions, but less rigid in nature. Less rigid in nature. They are less rigid in nature. And such rigid provisions are amended across the direction given under Article 368. Okay. So, after having a glimpse upon this particular classification, one can easily get to know that there could be possibly three different wayouts to amend the constitution. Broadly, two wayouts. One way out for amending the flexible ones, other way out for amending the rigid ones. But rigid provisions are further classified into two subcategories. So, see, by following certain common norms, there may be a possibility that in amending the rigid ones, I mean rigid provisions, certain differences may also be witnessed. See, to amend rigid provisions, you need to apply Article 368. Okay. So, under Article 368, if you look into Article 368 Clause 1, Article 368 Clause 1 talks about how to amend those rigid provisions which do not take part in division of power between center and states. While Article 368 Clause 2, while Article 368 Clause 2 tells us about the procedure which is needed to amend those rigid provisions which take part in division of power between center and states. So, yes, greater the rigidity, greater the complexity in amendment. Less the rigidity, less the complexity in amendment. So, flexible provisions are smoothly amended. Less rigid provisions, they invite some sort of difficulty. More rigid provisions, they invite greatest degree of difficulty. Okay. So see, prima facie, there are two sets of provisions. But when we try to enter into deeper, we simply find that we have basically three sets of constitutional provisions when it comes to constitutional amendment. Okay. So, look, constitutional provisions, flexible, constitutional provisions, rigid, but they are further categorized into, yes, less rigid and
more than
exactly more rigid, more rigid. One more thing, flexible provisions can be amended by the parliament by law, right? Here law means ordinary law. And in order to formulate ordinary law, which kind of majority is employed? Simple majority. Superb, superb. While amending the rigid provisions, which constitutional provision needs to be referred? Article 368. Article 368. Article 368 talks about which kind of majority? Two-third majority. Two-third majority. Special majority, not simple majority. Yes. Look, under Article 368, under Article 368, what's happened? Article 368 Clause 1 tells us about how to amend less rigid provisions, and at the same time Article 368 Clause 2 tells us about how to amend more rigid. How to recognize more rigid provisions? If you find a provision which takes part in division of power between center and state, that is called more rigid provision. And if a rigid provision is there, but that provision is not going to take part in division of power between center and state, that is no doubt rigid one, but less rigid, less rigid. Yes. So, yes, Article 368 Clause 2 is employed in order to carry out amendment across those rigid provisions which take part in division of power. So this is basically the theoretical discussion. Now let's have a glimpse upon practical discussion. See, here less rigid means state legislature, right? State legislature has no role to play. Fine, no role to play. But while amending the rigid provisions, I mean more rigid provisions, while amending the more rigid provisions, apart from parliamentary proceedings, a ratification of, how to change the color, hmm. Apart from parliamentary proceedings, you know, apart from parliamentary proceedings, at least 50% of Indian states need to ratify the amendment. I will be discussing about the entire proceeding, how the proceeding to amend constitution is followed. For that, we will be following the pattern given under Article 368(1) and 368(2). Under Article 368(2), it is given that if a constitutional amendment bill has been duly passed from both the houses of the parliament, that bill shall be referred to the state legislatures. Okay. So how many states are there in India? 28. 28. So obviously there are 28 state legislatures. So at least 50% of state legislatures need to ratify the constitutional amendment bill that has already been passed by the central legislature, means Parliament of India, with the help of simple majority. So in order to amend more rigid provisions, state ratification is also needed. But in order to amend less rigid provision, no state ratification is needed. In order to amend flexible provision, very easy, Parliament by law amend it. Is it okay? Yes. Yes, online students, have you got the points?
Yes, sir.
Okay. So look. So to amend flexible provisions, which kind of majority is employed? Simple majority. Simple majority is also called as ordinary majority. And remember, in order to discharge a particular kind of legislative business, if no specific kind of majority has been prescribed, means it is not known that which kind of majority needs to be employed to carry out the given parliamentary business or legislative business. In that situation, our constitution allows to go with simple majority. This is the reason why simple majority is also called as functional majority, right? Functional majority. See, for a particular legislative business, if no specific kind of majority is obvious, then you can apply simple majority and carry out the legislative function. So, to amend flexible provisions, you need to apply simple majority or ordinary majority or exactly functional majority. Okay. In order to amend rigid provisions, especially less rigid ones, special majority under which article? Good. Under Article 368. Very nice. 368 clause 1. So 368 clause 1, it limits the entire provision corresponding to constitutional amendment within the periphery of the parliament only. So entire proceeding will take place in parliament. But for more rigid provisions, more rigid ones, Article 368 clause 2 is followed, and here first of all the legislation, I mean constitutional amendment bill, will be passed in the parliament with two-third majority given under Article 368. Apart from this, a ratification of at least exactly 50% of states is needed. So two-third majority shall be employed on the floor of the parliament. After that, a ratification of a minimum of how many states is needed? 50%. Means if 14 states have ratified the amendment bill, the bill will deem to pass. Is it okay? So let's have a look into the entire proceeding which takes place within the purview of Article 368 clause 1 first, and then we will discuss about Article 368 clause 2. I think this one is Android setting, right? हाँ, ये बड़ा बेकार है, इसको हैंडल करना मुश्किल होता है. एक आता है बड़ी सिंपल सेटिंग, उसमें वो दिया रहता है सेटिंग 3 सेटिंग 5. दिस वन इज बेसिकली सेटिंग 5. अब इसमें स्लाइड आप चेंज नहीं कर सकते, मतलब रोटेट नहीं कर सकते. कहाँ कर सकते हैं? नहीं नहीं, वो नहीं कर रहा हूँ मैं. अगर इसी में मुझे इसको ऊपर नीचे करना हो तो आप दिस वन. चलो देखो जी, अब बताओ. हमने व्हाइट सेलेक्ट किया, ये आ रहा है ग्रीन. हाँ, देखो जी, ये आपको पहले से मालूम होना चाहिए कि आर्टिकल 368 क्लॉज 1 कहाँ यूज होता है. कहाँ यूज होगा? टू अमेंड दोज रिजिड प्रोविजंस which do not take part in division of power between center and states. So under Article 368 it is given that, see, here is the parliament. Parliament has two legislative houses along with the office of the President of India. So Lok Sabha, Rajya Sabha and office of President. Okay. So they combinedly constitute the parliament. Article 368 clause 1 says that first of all it is needed to prepare a constitutional amendment draft. In that particular draft, all the issues have been enumerated, that what sorts of amendment you seek to carry out, you intend to carry out. Okay. So first of all, a constitutional amendment bill will be formulated, will be prepared. Constitutional amendment bill. This constitutional amendment bill can be introduced into the either house of the parliament. Either house means either in the Lok Sabha or in the Rajya Sabha. Let us consider that this constitutional amendment bill has been introduced into the Lok Sabha. Remember, the Lok Sabha shall be passing this bill with the help of a special majority that we have discussed within the purview of Article 368. So Lok Sabha shall be passing this constitutional amendment bill with the help of a special majority given under Article 368. If Lok Sabha passed it, then it will be transmitted to the Rajya Sabha. If Lok Sabha fails to pass the bill will be declared as dead. The bill will be quashed. Let us say Lok Sabha has passed the bill with the help of the requisite kind of majority. After that, the bill has been transmitted to the Rajya Sabha. See, Rajya Sabha also needs to pass the bill with the help of similar kind of majority which has been put into effect in Lok Sabha. Means Rajya Sabha shall also be passing the bill with the help of a special majority given under Article 368. Once Rajya Sabha passes it, it will go to the office of the president. And remember, after getting assented to by the President of India, the Constitutional Amendment Bill becomes a Constitutional Amendment Act, and the required changes will be made by issuing a notification by the Government of India. Is it okay? So, after getting assented to by the President of India, the amendment procedure will complete. Is it okay? But one more thing. Suppose the bill has been properly passed from Lok Sabha, but Rajya Sabha fails to pass it. What will happen then? The bill will collapse. The bill will declared as dead. Why? Because Rajya Sabha has no power to cause delay across a constitutional amendment bill. In respect of passing constitutional amendment bill, Lok Sabha and Rajya Sabha both have equal level of jurisdiction. Both have equal level of jurisdiction. One more thing. Before 1971, if a constitutional amendment bill has been presented to the President of India after passing from both the legislative houses, namely Lok Sabha and Rajya Sabha, President of India could enjoy, different choices, either to provide her ascension upon the bill or to apply her veto power. But after 24th Constitutional Amendment Act, which took place in year 1971, it was made mandatory upon the President of India that once a constitutional amendment bill, after duly passed from both the houses of the parliament, has been presented before her house, her office, it is obligatory for her to provide her ascension upon the bill. Have you got the point? Yes. So through 24th Constitutional Amendment Act 1971, the provision was made like if both the houses of the parliament duly passed a constitutional amendment bill, duly passed means properly passed. So if a constitutional amendment bill has been passed properly from both the houses, the bill will be transmitted to the office of the President of India. Here, the President of India cannot apply her veto power against the constitutional amendment bill. Why? Because of a new arrangement that was made in year 1971 via means of 24th Constitutional Amendment Act. Means if a constitutional amendment bill has to be entertained by the President of India, the President of India has been left with the only choice, and that choice is to provide her signature. Is it okay? Yes. So this is how less rigid provisions of Indian Constitution are passed. Now, when it comes to more rigid provision, the subject matter of more rigid provisions is Article 368 Clause 2. See, again the proceeding will be started from Parliament. Let us say, and see, it is not formally given under Indian Constitution that which provisions should be treated as less rigid, which provisions should be treated as more rigid. On the basis of the application of, constitutional amendment procedure, I am telling you, you know. So look, Article 368 Clause 2 says that first of all, a constitutional amendment bill is prepared. Why this bill is prepared? This bill is prepared to cause amendment across such provision of Indian Constitution which takes part in division of power between center and states. Fine. So this amendment bill can be started from the either house of the parliament. Let's say it is started from Lok Sabha. The Lok Sabha shall be passing with the help of similar kind of majority which you saw just now in case of less rigid. So the majority given under Article 368, two-third majority. So this amendment bill will be passed in Lok Sabha with the help of two-third majority. Once it is passed, it will go to Rajya Sabha. Rajya Sabha shall also be passing it with the help of similar majority. But after getting passed from the Rajya Sabha, now the bill won't be transmitted to the office of the President of India directly. Rather, before transmitting it to the office of the President of India, it will be transmitted to different Indian states. All the 28 Indian states. Are you getting this point? After the constitutional amendment bill has been duly passed from both the houses of the parliament, namely Lok Sabha and Rajya Sabha, it will be sent to the legislative assemblies of all the 28 Indian states. And such legislative assemblies would be passing this bill, or not passing, would be simply ratifying this bill, simply affirming the bill which has been passed from parliament with the help of simple majority. That is called state ratification, right? State ratification. So the state legislative assemblies of all these 28 states will try to ratify it. Remember, it is not mandatory that each state has to ratify it. Even if means at least 50% of Indian states need to need to ratify the constitutional amendment bill. Need to ratify the constitutional amendment bill duly passed from the parliament. Are you getting this? Or rather, duly passed from, yes, both the houses of the parliament. One more thing. If less than 40%, less than 50% of Indian states have passed it, ratify it, in that case, the bill will remain pending with the states. So it is obligatory, it is required that at least 50% of Indian states need to ratify this constitutional amendment bill. Let's say if at least 50%, a minimum of 14 states out of 28, if they have ratified the constitutional amendment bill which has been duly passed from both the houses, then the bill, I mean this constitutional amendment bill, yes, will be sent to the office of the president. Don't you think it shows slightly greater degree of complexity? Yes. And now, once the bill has been, I mean, constitutional amendment bill has been, transmitted to the office of the president. Now, the president of India will be simply providing her signature upon the bill, and once the bill has the signature of the president, this constitutional amendment bill will become a constitutional amendment act. So this is the entire procedure of constitutional amendment.